Godoy in Buenos Aires, Argentina. Thank you for joining our webinar. Today, my colleagues and I are going to talk about the legal framework of lithium in South America. The Lithium Triangle includes Argentina, Bolivia, and Chile, and holds more than 50% of the world's lithium resources. However, there was an important discovery in Peru last year, so the Lithium Triangle may be on its way to becoming a square. Argentina has the largest identified lithium resources worldwide, 9.8 million tons, which is equal to 18.5% of global lithium resources. Most of Argentina's lithium deposits are in the north of the country, in the provinces of Salta, Jujuy, and Catamarca, that is, in the salt lakes near the Bolivian and Chilean borders. Chile has 7.5 million tons of reserves, the largest worldwide, and 8.4 million tons of identified resources. Most of Chile's lithium reservoirs are located in the north of the country, mainly in the Atacama, Maricunga, and Pedernales salt lakes. Bolivia has around 17,000 square kilometers of salt flats, and the US Geological Survey estimated Bolivia's lithium resources to be around 9 million tons. The Uyuni Salt Flat, with its area of 10,000 square kilometers, is thought to be the largest lithium reservoir in the world. And finally, Peru might become the last member of this club. The Canadian company Plateau Minerals discovered a deposit in Puno, in the south of Peru, estimated in 2.5 million tons. This places Peru in the lithium map.
Many thanks, Juan, for this kind introduction. We are very pleased to participate in this webinar with such a distinguished colleagues and good friends. And in addition of having abundant lithium resources, the political and the legal environment are also very relevant for the development of the lithium industry. We all know that mining projects are long-term projects, so having political stability and a clear and a strong legal framework would be a key element for any mining company before making an investment decision. As a preliminary overview, we could say that in the case of Peru, Bolivia, and Chile, the central governments have sovereignty over natural resources. In Argentina, the situation is different because Argentina is a federal country, and there, each province has control over the natural resources located within its territories, meaning that each province has jurisdiction to set its own regulations, procedures, and grant concession. However, such provincial rules cannot alter the rights and obligations established by the Federal Mining Code. In Bolivia, administration of mining is carried out exclusively at the national level, and mining rights can be granted through exploration licenses or administrative mining contracts governed by the law of mining and metallurgy. For lithium, there is a specialized mining regime where the entire chain of mining activities is exclusively attributed to the government through a state-owned company, Yacimiento de Litio Boliviano, who has faculty to form partnerships with private parties. In the case of Chile, all mines are property of the state, and the exploration or exploitation of mineral is made by general rule through mining concessions that are granted through judicial resolutions in non-contentious proceedings. The holder of the concession will have ownership right over such concession constitutionally protected, and the most relevant body of law will be the Chilean Constitution, the Organic Law of Mining Concessions, and the Mining Code. We should know, however, that lithium is considered as a strategic mineral reserved to the state of Chile, and therefore unsafe for concessions granted before 1979, lithium is not considered as a concessible mineral covered by the mining concession. Because of this, the exploration or exploitation of lithium projects in Chile can be made either through administrative concession or a special operations agreement to be signed by private or state-owned companies with the state of Chile. In Peru, mining rights are regulated by the single uniform text of the General Mining Law. Under this law, prospecting activities do not require an authorization from the authorities, but for exploration or exploitation activities, companies must obtain an administrative concession from the government. We will provide more details on how mining concessions are granted, but before doing that, my colleague from Peru will give you a quick overview of each country foreign investment framework.
Foreign investment framework. The promise of equal treatment for foreign investors is generally recognized either as a constitutional principle or treaty obligation in each country. For example, Article 20 of the Argentine Constitution guarantees equal rights and treatment to all foreigners residing or conducting businesses in Argentina. Article 66 of Peruvian Constitution also states that no differential treatment will be given between Peruvian and foreign investors. The Andean Community of Nations, which both Bolivia and Peru are members of, also established that foreign investors will have the same rights and obligations as national investors. These principles are further implemented and regulated through domestic legislations. In Argentina, for instance, the law on foreign investments guarantees the same rights and obligations to foreign investors and provides that they are entitled to carry out business activities under any business vehicle available under the law, to freely transfer profits and liquidation proceeds abroad, and to access domestic financing under the same conditions as Argentine nationals. In Chile, the foreign investment regime also recognizes the principle of non-discrimination between foreign and Chilean investors. Registered foreign investors can freely transfer capital and liquidation proceeds from their investments in Chile. Foreign investors will also have equal access to the formal exchange market. Of course, sometimes against the general principle of equal treatment, exceptions and limitations may apply. For example, in Bolivia, while the law for promotion of investment recognizes investments in developing strategic resources such as lithium as a preferential investment, it also states that national investments have priority over foreign investments. In Peru, under Article 71 of this constitution, foreigners are not allowed to acquire mining concessions or property rights within 50 kilometers from the country's borders, unless they are given permission by the executive branch, which procedure includes a favorable opinion from the armed forces. Regarding dispute resolution mechanisms, currently Argentina, Chile, and Peru are parties to the ICSID Convention. International arbitration is generally an accepted mechanism for resolving disputes in these countries. In practice, dispute settlement procedures may be subject to the provisions in the bilateral investment treaties between the host country and investor's home country. The case of Bolivia is very different, unfortunately, since it withdrew from the ICSID Convention in 2007 and generally does not recognize or permit international arbitration where the dispute is against the state or a state-owned company. The local law establishes that the administrative contracts through which the government grants mining rights cannot be subject to arbitration. However, the law also contains specific provisions concerning foreign investments in the case of state-owned companies, which actually allows the choice of arbitration. So, if Yacimientos de Litio Boliviano enters into partnership with third parties through the commercial vehicles for the development of lithium projects, arbitration can be available to the parties. This sums up the first part of our webinar. My colleague Gonzalo Rez will start the second part on mining exploration mechanisms.
During the second part of this webinar, we will try to cover some legal aspects applicable during the exploration phase. We will try to address common questions such as what are the applicable permits or authorizations needed for exploration activities, Are they needed at all? Or are there any specific consideration with regard to lithium? Well, exploration rights are granted in various forms in each country, and the stage at which a mining permit becomes necessary varies country by country. In Peru, for example, prospecting activities, as opposed to exploration, do not require any concession or permit, although they are subject to prior third-party rights over the same area and certain exceptions in urban, archaeological, or national defenses area. In Argentina, it is possible to discover mining deposit accidentally and request for an exploitation concession on such basis, without the need of having obtained previously an exploration permit. However, it seems much more advisable to apply for an exploration permit when conducting exploration activities, because the conduction of such activities without a permit or the consent of the surface landowners might lead to liabilities and the payment of the damage caused. Also, exploration permits are enforceable against third parties and give the holder the right to obtain exploitation concession even if the mining deposits are discovered by a third party in the defined area. If the area is entirely free from previously granted mining rights, then the permit holder will have an exclusive right to conduct its exploration activities.
What needs to be obtained and how? At the exploration stage, the corresponding mining authorities issue an exploration permit in Argentina, exploration license in Bolivia, and exploration concession in Chile. In Peru, it's different. The mining concession covers both exploration and exploitation activities. In Argentina, the requirements to obtain an exploration permit are regulated in the Federal Mining Code and apply equally to all provinces. However, procedural details vary from each province. Depending on the location of the mine, procedures can be administrative or judicial in nature. The Lithium Triangle includes provinces of Catamarca, Jujuy, and Salta. All three provinces have their own mining procedural code and designate the judicial branch as the competent authority with respect to the mining industry. In Bolivia, the Mining Administrative Jurisdictional Authority is the responsible entity for granting exploration licenses. To request an exploration license, all requirements established in the law, ranging from the proof of the existence of the mining entity to technical requirements, must be complied with. However, there are various restrictions over the granting of exploration licenses. For instance, some exploration rights are reserved exclusively for the state and state-owned companies, and this is especially the case for lithium. In Chile, the standard practice will be to apply for an exploration concession granted through judicial resolution. However, as lithium is not a concessible mineral covered by a mining concession, the applicable special agreement should establish specific obligations in terms of exploration, development, delivery of information, among others. In Peru, applications for mining concessions are submitted to the Geological Mining and Metallurgical Institute, called INGEMET, which will review the application and prepare technical and legal reports, confirming, for instance, among others, the availability of the area. It needs to be stated that the same mining concession is valid for both exploration and exploitation mining activities. Following the grant of the mining concession, the concessionaire needs to also obtain an authorization in order to start the exploration and in turn the exploitation activities allowed under the same concession. To obtain these authorizations, the concessionaire must submit various documents evidencing compliance with relevant environmental and social obligations, for instance, as well as demonstrating land ownership or landowner's authorization.
Let's move to the term, area, and benefits of the grant. So, once you get the exploration permit, the next question is, what are the conditions regarding the term and the area under concession? With the exception of Peru, exploration rights are typically granted for a limited period and surface area within which mining companies can carry out exploration activities. In Peru, mining concessions do not have a term limit and can be held indefinitely. In the case of Argentina, the exploration area for each permit is divided into 500 hectare surface units. Each exploration permit can include up to 20 units. So, the maximum area under an exploration permit is 10,000 hectares. Also, as the permit term runs, its size should be gradually reduced. The term of the exploration permit will depend on the size of the area granted. A 500 hectare permit is good for 150 days, and with each additional unit, the term increases by 50 days. Therefore, the longest possible term for an exploration will be 1,100 days. On the other hand, in Bolivia, exploration licenses are valid for up to 5 years and can be extended for another 3 years if justified. Once you get the exploration license, you must start exploration activities within a year. The maximum mining area granted under an exploration license is 500 grids, and each mining grid is 500 square meters. Nonetheless, as previously stated, this does not apply to lithium. This is important to note. In Chile, mining exploration concessions have duration of 2 years and can be extended for 2 additional years, in which case the holder shall waive at least half of the area under concession. The CEOL, however, can also establish additional exploration term for different phases that need to be complied to keep the CEOL in force. Now, as regards to grantee obligations, generally speaking, exploration permit holders are subject to 5 types of obligations. The first obligation is the payment of fees to the granting authority in consideration for the exploration permit. For example, parties have to make a one-time payment in Argentina and Peru. Failure to comply with this obligation can lead to a cancellation or revocation of the grant. In the case of Bolivia and Chile, entities holding exploration licenses or concessions respectively must pay an annual fee. The second obligation relates to agreement with the surface landowners on issues concerning the use of land. It is very important to understand this point, because all 4 countries here are civil law jurisdictions, which means the ownership of the underground mining property is separate from the surface land. So, the grant of mining rights from the government does not automatically entitle the permit holders to use the surface land. They are encouraged to first identify and reach an agreement with the relevant surface landowners. If not, they can ask the mining authorities to intervene and impose an easement. The third category is compliance with environmental and social obligations, which can be both a precondition for obtaining the exploration permit as well as an ongoing obligation after the permit is granted. We will discuss these obligations in the next part of the webinar. Fourth, permit holders are usually required to carry out a minimum level of activity. While under Chilean regulation this is not required to keep the mining concession in force, it could be established in the CEOL to keep this latter agreement in force. In the case of Argentina, parties are required to submit a plan outlining their activities. For Bolivia, as mentioned previously, exploration license holders must start exploration activities within 1 year from the grant of the license, and they must not abandon or stop their activities for more than 1 year during the term of that license. In Peru, since mining concessions cover both exploration and exploitation activities and do not have a limited term, concessionaires are subject to a minimum annual production requirement, starting from the 11th year of concession. If the minimum annual production still cannot be reached by the 30th year, the concession will automatically expire. The fifth and final obligation relates to permit holders' general duty to regularly report to the corresponding authorities about the conditions and progress of their mining activities. Also, in Argentina and Bolivia, once the permit expires, permit holders need to submit the information related to the final results of the exploration. In the next part of the webinar, my colleague Juan Sonoda will talk about the legal restrictions during the exploration stage, and then we will move on to the exploitation stage.
In some countries, lithium is treated as a strategic resource, and this must be carefully considered when planning an investment. On the one hand, lithium can be freely explored and extracted in Argentina, subject to the same restrictions as any other mineral. For example, the largest exploration area that can be awarded to a single company is 200,000 hectares per province. You have no limits for mining concessions. This is for exploration only. Companies must also establish a corporate presence in Argentina to be allowed to conduct mining activities. In Bolivia, on the other hand, the government has a monopoly over lithium mining. In April 2017, the state-owned company Yacimientos de Litio Bolivianos was created with the express purpose of handling the entire chain of exploration, development, production, industrialization, and commercialization of lithium. Bolivian law sets forth that the government will own 100% of the lithium production chain, except for the industrialization stage, which can be developed in association with private parties. Also, most of the salt lakes in Bolivia are fiscal reserves, which means that they can only be explored and developed by the government. In Chile, lithium is also reserved to the government, but its exploration and exploitation can be performed by private parties through administrative concessions or special operation agreements. Administrative concessions are granted directly by the government of Chile through a supreme decree issued by the president. Special operation agreements are contracts entered into between the government and private entities and consist in the grant of a permit for lithium exploration or exploitation for a fixed period of time. According to the political constitution of Chile, the President of Chile may terminate administrative concessions or special operation agreements located in areas declared strategic for national security, and it can happen at any time and without a cause, but with just indemnification. In Peru, similarly to Argentina, lithium can be explored, extracted, and commercialized in the same manner as any other mineral.
In order to obtain exploitation rights, we will see important legal difference among our countries. In certain cases, the conduction of certain activities will be needed, or the payment of certain amounts, or to enter into a special agreement with the applicable state. For instance, in Argentina and Chile, a separate mining concession named exploitation concession will be needed for exploitation activities. In Bolivia, there is no exploitation concession mechanism, and exploitation activities are conducted through execution of mining contracts between private operators and the government, though this general system is not available for lithium projects. In Peru, since mining concessions cover both exploration and exploitation activities, concessionaires only need to obtain another authorization to start exploitation activities. The concession system in Argentina is a highly discovery-oriented system, meaning that it's possible to obtain a mining concession following an accidental discovery without the need of having a previous exploration permit. Once a discovery is made, the discoverer should submit a statement of discovery with a sample of the minerals found to determine their class and type. In the meantime, to obtain a definitive title to the mine, the discoverer must also perform the so-called labor legal work in order to evidence an in-place deposit so that the direction, slope, and thickness of the deposit can be recognized and the system and type of minerals can be verified. A subsequent measurement and survey operation will be needed to obtain a definitive title to the mine. The concessionaire must also pay an annual fee to keep its title in good standing. Payment could be in the form of royalties and/or canon. Royalties are based on a percentage introduced by the provincial regulations, while canon payments are mandatory under the Federal Mining Code. In Peru, mining concessionaires who plan to obtain and authorization for exploitation activities are generally subject to the same requirements for the authorization of exploration activities. The concessionaire needs to submit a technical information document including the annual mining plan and activities to be carried out during that one-year period. As mentioned before, only the Bolivian government is entrusted with the lithium production chain, and it includes both exploration and exploitation activities. The available alternative for private parties interested in investing in the Bolivian lithium industry could be, for instance, to participate in direct procurement of goods or service conducted by the Bolivian National Company, or to enter into temporary associations or joint ventures arrangement with such company, or to form a state mix or mixed company with the Yacimiento de Litio Boliviano. But in all these two latest cases, the Bolivian government must keep control or a majority participation interest. In Chile, exploitation concessions are granted also by a judicial decision, and once granted, they are of perpetual duration, subject to an annual payment of the license fee. So no work or activities are needed to keep the exploitation concession in force. However, for lithium projects, it will be standard to see in the special operation agreement certain milestones, such as certain exploration activities, feasibility, construction, that need to be complied in order to keep the agreement in force. This sums up the third part of our webinar. In the final part, we will review environmental and social license and tax incentives in each country.
Environmental responsibilities. As we all know, mining activities are environmentally and socially sensitive. That's why all countries impose social and environmental obligations. We will briefly discuss the main requirements in each country. First, let's start with environmental obligations. In Argentina, submitting environmental impact reports and obtaining the corresponding environmental approval is an integral part of the mining concessions application. At the federal level, the general law on the environment and the minimum standard for preservation of glaciers and periglacier area provide the basic legal framework. At the provincial level, each province certainly has the authority to enact its own regulations. In Bolivia, it is stipulated under the law that environmental licenses must be obtained for all mining activities and will be valid for 10 years. In addition, it may also become necessary to obtain the environmental permit for specific risks related to dangerous chemical substances. Also, environmental impact evaluation and environmental quality controls are mandatory for all activities that affect the natural resources and the environment. In Peru, applicants have the obligation to obtain the corresponding environmental management instrument, which includes an environmental impact statement or assessment, depending on the scale of the project. In addition, mining companies must submit and execute closure plans and post financial guarantees to secure compliance with environmental requirements during the life of the project. Lithium deposits in Peru appear to be associated with uranium. It was established that environmental management instrument for projects involving the extraction of mineral with radioactive characteristics required a technical opinion and approval from the Peruvian Nuclear Energy Institute. In Chile, the General Law on the Environment created the Environmental Impact Evaluation System and stipulates that activities that may cause environmental damage must be evaluated prior to their execution. Accordingly, an Environmental Impact Declaration, DIA, or Environmental Impact Study, EIA, must be prepared. If the project causes any of the environmental effects, an EIA must be prepared. If not, a DIA will suffice. An environmental qualification resolution will also be issued by the authorities, either approving or eventually rejecting the project.
Another key aspect to consider in lithium mining is the role of indigenous communities. Argentina, Bolivia, Chile and Peru are all parties to the International Labour Organization's Convention on Indigenous and Tribal Peoples 169. To various degrees, ILO 169 provisions have been adopted by these countries' domestic laws and enforced by their courts. Most importantly, this convention sets forth that indigenous communities have a right to be consulted on projects that may affect them. In Argentina, the ILO 169 convention ranks higher than domestic laws. Argentine courts have stopped projects for not complying with prior consultation requirements. In addition, the Argentine Congress has suspended all evictions of indigenous communities from the lands they occupy, pending completion of an indigenous land survey. In Chile, any mining project requires a prior consultation process with the community in general, which includes indigenous communities. This is a prior requirement of the environmental licensing of any mining project. In Bolivia, it is established under the Constitution that indigenous communities have the right to prior consultation concerning the exploitation of non-renewable resources in their territory. Under the Peruvian law, the Peruvian government must hold a prior consultation process with indigenous communities. In all these countries, the right to consultation does not mean that the project needs to obtain the community's approval. However, in practice, it would be almost impossible to develop a project against a strong opposition from indigenous communities and the community in general. The need for lithium is increasing exponentially every year, and the world is turning to South America to satisfy this demand. For now, Argentina is the only country where these two conditions are met: a vast amount of lithium resources and the possibility of extracting them without restrictions. Chile is already a leading lithium producer, and its government seeks to invite tenders for special operation agreements, which will grant investors 100,000 tons of lithium for exploitation under 20-year terms.
Now, tax incentives. Our final topic of discussion is related to tax incentive programs. Generally, mining companies operating in Latin America are subject to the usual tax obligations as everywhere else in the world. For foreign investors, usually there are also tax burdens associated with the import and export of equipment, goods, and products. However, in order to promote investment in the mining industry, all countries have introduced tax incentive regimes. In Argentina, the mining investment law has been enacted to provide special benefits to investors and to reduce the risk of mining activities. Benefits for companies with qualified projects at the exploration stage include VAT reimbursement, exemption from the payment of customs duties and fees for capital assets used in mining activities, and exemption from the minimum presumed income tax. Qualified projects at the exploitation stage will enjoy fiscal, foreign exchange, and custom duty stability benefits for a 30-year term, starting from the filing of the feasibility study. These incentives include various income tax benefits, option to capitalize 50% of proved mining reserves, royalty cap at 3% of the mine mouth value of extracted minerals, option to import capital goods and equipment for activities without paying import tax or statistics duty, exemption from or reduced gross turnover tax rates, mineral export tax exemptions, and stamp tax exemptions, which is allowed in most provinces. In the case of Bolivia, the mining law allows for a 40% reduction over mining royalties under the administrative contracts for activities promoting the smelting, refining, and industrialization of minerals. Also, activities related to the sale of minerals and metals within the local market will benefit from a 40% reduction on mining royalties. Companies that produce minerals or metals with added value can also benefit from a 40% reduction over the tax on the additional aliquot to the corporate income tax. In Peru, instead, title holders performing mining exploration activities in the pre-production stage can request a definitive refund of the VAT paid upon the import of local purchase of certain goods and services. Additionally, mining investors can enter into legal and tax stability agreements with the government. Legal stability agreements guarantee stability in the income tax regime for a period of 10 years. Tax stability agreements can be valid for 10, 12, or even 15 years and do not include additional fees or contributions. On the other hand, in Chile, as a general rule, income generated by Chilean entities is taxed at two levels. First, entities will be subject to an annual corporate income tax. At the second level, shareholders will be subject to a 35% withholding tax in case they are non-residents, or personal progressive tax if they are Chilean residents. However, shareholders may use 100% or 65% of the amount paid as corporate income tax as tax credit. Although not a tax, the CEOL would normally apply certain royalties payable to the state of Chile in the form of a percentage out of the sales of lithium products, plus a percentage out of the annual operational margin of the company having a CEOL. These percentages are determined on a case-by-case basis on each CEOL. Finally, lithium exports are exempt from VAT in Chile.
The need for lithium is increasing exponentially every year, and the world is turning to South America to satisfy this demand. For now, Argentina is the only country where these two conditions are met: a vast amount of lithium resources and the possibility of extracting them without restrictions. Chile is already a leading lithium producer, and its government seeks to invite tenders for special operations agreements. Each agreement will grant investors 100,000 tons of lithium for exploitation under terms of 20 years. The same as Argentina, Peru does not have restrictions on lithium mining, and the discoveries in Puno present opportunities for exploration and development. Finally, Bolivia presents the promise of huge untapped resources waiting to be explored and developed. And this concludes our webinar. You have sent us questions through the webinar resources and emails. If not, please send us your question now, and we will answer them during the next 20 minutes. Thank you.
Just one, as part of the process to obtain a special operation agreement, certain administrative resolution might be needed. One resolution, an important resolution, will be a resolution from the Comisión Chilena de Energía Nuclear, or Chilean Commission of Nuclear Energy. And in the past, this resolution normally has dealt with the amount of, or the ton of lithium that could be extracted, as well as the term of the exploitation. And in a special operations agreement, such resolution basically will be part of the special operation agreement, because that agreement might fix this amount of ton, the term of the agreement, as well as other aspects of the agreement. Thank you.
Hello. Thank you for the question. The question that I have received says, could you elaborate on how private parties can participate in the lithium industry in Bolivia? Well, based on the fact that actually basically the whole production chain of lithium in Bolivia is controlled by the state through the state company known as Yacimientos del Litio Boliviano, YLB, then it is important to note that the Bolivian law also provides for the fact that other related activities such as semi-industrialization, industrialization, and the processing of residues are to be, these can be treated alongside with private investors, whether national or foreign. So based on this, there are also basically three main ways by which private investors can participate in the lithium industry in Bolivia. Okay, the first one would be the provision of services, goods, and works to the state. For instance, YLB has procured the construction of a plant for obtaining lithium carbonate through an EPC project. On the other hand, we have the second option, which would be to execute association agreements with YLB, by which what the state requires is to have a majority participation. Nevertheless, these strategic ways of associating can be properly structured and organized in order to participate in the aforementioned activities. And the third and last one would be to incorporate state mixed companies or mixed companies in which, as previously stated, YLB would have a majority participation of a minimum of 51%. Okay, these type of companies are already in place, and YLB is already starting and getting into projects this way. Thank you.
Hello, everyone. It was asked to me if there's a special requirement, either technical, economical, among others, to obtain a mining concession in Peru. In Peru, fortunately, there's no specific or special requirement in terms of economic requirements or capacity or technical requirements for obtaining a mining concession. So anyone is entitled to acquire or request a mining concession from the central government. After obtaining the concessions, for sure, a lot of requirements must be obtained. For instance, permits regarding the surface area, the environmental permits, among others. And the government also has established an incremental penalties for not reaching minimum production levels. That's the way that the state controls that the mining title holders are the ones that the government require, or the ones that have the capacity of the qualities in order to develop a mining project. Thank you very much.
Hello, we have one last question for Argentina, which is if there are local content requirements for the award of concessions. And the answer is that there are no formal requirements on local content, local suppliers, but this is something that it is informally done, it is informally required by the authorities, and it normally happens when the company has filed its final environmental impact assessment for the production stage of the project, and then come into play negotiations with authorities that most of the time include local content, maximizing the local production, such as having a production plant on the site and not just exporting the brine, and also the hiring of local labor. All those things, although they are not formally within the concession framework, are discussed at the last stage before a project goes into production. And the exact local content that a project will have will depend on these discussions. And with this, we end our webinar. We hope it has been useful and interesting for you. And we thank the wonderful job of all our panelists and the support team. You have been all wonderful. And most importantly, we thank all the audience for joining us. And until the next one, thank you.